I audible?
Yes.
You're barely
Can you
audible.
hear me? Okay, 1 minute. No. Can you hear me now?
Yes,
sir.
very much. Please carry on.
So, respected faculties, Dr. George Paul, Dr. George Correa, National President, Dr. Manjunath, past President, past Secretary, National Secretary, Dr. Preetham, Dr. Abhilasha, and the participants have joined from the other than the Kerala state branches from outside, our own members, friends from a profession, IDA profession. A warm welcome and good evening to one and all. It's indeed a tough time we are facing right now during this third wave. I know all of us having tough practice. Yeah. Is there any audibility issue?
Mahil,
sir.
you can continue, please.
Yeah. As we all know that we are facing a very tough time right now in this third wave of this pandemic. And we are having a tough time in our practice as well as outside in our society itself. We started to have a couple of programs, physical programs as such, with CMEs, which we're going to enlighten our members as well as for the promotion of our profession. But unfortunately, I don't know how it's going to end up. Anyhow, having this virtual thing in our hand, we thought we will make the association activities bit lively. So we had already purchased the Zooms and we thought we'll make use of it to the maximum. So we are going with a couple of programs. Instead, we had a program which was coming up, physical program for that TMJ on NIMS, which has already got cancelled or postponed it for the time being. But still, we have a couple of virtual CMEs which are coming up. So we just keep planning to keep it in the full-fledged active phase for the professional activities as of now. I hope this lecture of Dr. George Paul and Dr. George Correa, with the interactive discussion with all our profession members in the profession, would benefit the medical legal aspects of our practice, the negligence aspects of it, which I would also be a part of it to share my own experience if time permits, because I have undergone a stage of this and is facing a litigation for the past 14 years. So that is why I personally insisted on, when Dr. Aglesh called me up and insisted on this. We thought we will have a have a good lecture on this particular session. So I just conclude my welcome address with the same and just handing over to Dr. Leda for introducing the moderator, Dr. Ravi, who is the moderator for the show. Over to Dr. Leda to introduce the moderator. Thank you.
Yeah. Good evening, all. I'll just say, to err is considered human, but in medical profession, it is called negligence. It is always better to keep us updated or prepared to face if any legal issues come our way. We have, like Dr. Joseph said, we have eminent speakers among us who can talk about the legalities of practice, malpractice, and negligences, with Dr. Ravi Veeraraghavan as the moderator. Ravi Veeraraghavan is the professor and head of the Department of Maxillofacial Surgery in Amrita School of Dentistry. He is an alumni of GDC Trivandrum and Calicut. He is a national and international board-certified maxillofacial surgeon with advanced training in various specialties of maxillofacial surgery. He is actively interested in medical legal cases, and with a very keen, sharp analytical mind, I'm sure he would be able to enlighten us all on the various nuances of maxillofacial surgery and the negligence part of it, especially, along with the speakers. I'm very happy to invite Dr. Ravi, my dear friend, to start the session. Over to Ravi.
Thank you very much, Dr. Lata. Very happy to see a large number of attendees, much more than what we had initially thought we would get. Well, medical negligence lawsuits are a Damocles sword that is always hanging above the heads of every clinician. We always dread when it will fall on us. As we know well, the unique and multidimensional nature of our specialty makes us particularly vulnerable on multiple counts. On the one hand, those of us who are running dental clinics or work in such clinics face the risk of adversities related to a small health center with minimal facilities. Those working in hospitals face problems of quite a different dimension related to anesthesia, major surgeries, inpatient issues, etc. Then there is a unique issue that we face. That's a problem of the surgeon not having a medical degree. Once a problem comes up, the lawyers will dig up all these. And since negligence lawsuits are relatively rare, it usually comes as a nasty surprise to the clinician, and we tend to panic. The average clinician has very little idea of these legal matters, and so we do not know what to do. To clear our doubts and misgivings about the topic today, we have two illustrious speakers with us. Both are pioneers in our specialty, two charming individuals who have made a mark in maxillofacial surgery as well as in the arena of medical legal lawsuits. Both are doubly qualified too, in the sense of possessing an OMFS degree as well as a law degree to boot. Today's session is planned as a 1 hour module, a short session. We'll have first 2 short lectures of about 15 minutes each, followed by a half-hour discussion session. All the questions which you want to ask the speakers may please be posted in the chat box privately to me. I am Ravi Veeraraghavan. I repeat, all the questions that the audience want to ask the speakers may please be posted privately to me. The first speaker of the day, I'm very happy to introduce Dr. George Scaria. He did his BDS from GDC Trivandrum, MDS from GDC Kozhikode. He has a PG in marketing management as well. Finished LLB law degree from Kerala Law Academy, Thiruvananthapuram. Currently pursuing LLM from Annamalai University. His current designation is Associate Professor and Unit Head at OMFS Department at Government Dental College, Thiruvananthapuram. More than that, as a person, he is well known among his colleagues as a very amiable and pleasant person, well versed in governmental and other official procedural matters, and he is always ready with a helping hand to everyone. He'll be talking to us today about the concept of medical negligence, the basic concept, as well as its implications as related to clinical practice. Welcome, Dr. George Scaria.
Thank you, Dr. Ravi, for the introduction, and good evening, friends. Like Dr. Ravi told, I'll be giving an introduction or a slice on medical negligence, what constitutes negligence, and how to address it. And this is a short presentation, so we'll be covering only the relevant points of. So, as we go through the newspaper on an everyday basis, we see so many news like this. That means some are in favor of the doctor, some are in against the doctor. When some means allegation of negligence against the doctor, which serves as a good recipe for the newspapers. And also some may be due to non-addressing the issue in the court properly. Once in a while, doctors are convicted also. So we are looking into what is negligence and what are the common grievances which are portrayed as negligence. And you know that maxillofacial surgery or dentistry as such is having complications which are accepted in day-to-day practice. But majority of the time, the complications are also portrayed as negligence. And the other common grievances are listed here as lack of care, abandonment, fees, confidentiality, like that. Even the procedures and the prescription will serve as a reason for allegation of negligence. And what is actually negligence? A patient who is under a contract of care has suffered a hurt, grievous hurt or injury or loss of life. That is the one. And what is actions not amounting to negligence? Not accepting patients except in the dictum to continue to treat a patient, or not attending on patients outside the clinic timings, collection of fees and referring the patient to other suitable centers. And always dissatisfaction of the service rendered in the one form or other is the patient's allegation. That is which is portrayed as a negligence in the court of law or in the public. Major issue in the complaint is negligence, whether it is one of among the listed items, whatever it is for the patient, it is to the common factor that is negligence. And let us analyze the elements of negligence. When a patient is coming to you, there is a duty to care. That is an implied duty or an expressed duty. And when there is a violation of duty and an injury resultant to that, and the injury resultant to the violation of the duty, those are the elements of negligence. And the burden of proof. Burden of proof is whether the complainant or defendant, the one who is making the allegation that you are negligent, has to prove it. That means the complainant has to prove it, not you have to prove that you are not negligent. That is a factor favorable for us. That means the patient or his relative who is alleging the complaint that there is negligence has to prove in the court of law by proper evidence or other supporting evidences that there is an element of negligence. Exception to the rule is the res ipsa locator is a Latin term that means the thing speaks for itself. For example, I will give you an example. In maxillofacial surgery, the orthodontist has directed you to extract the first premolar. You have extracted the second premolar by mistake. If you have not replaced it then and there, the matter speaks for itself. That means you don't have the second premolar there instead of the first premolar remaining in the proper position. The matter speaks for itself. And when the court analyzes the negligence, sees whether there is a contract of service, whether there is a duty to care, whether there is a violation of that duty, and whether there is an injury due to that violation, and is the injury related to the violation of care, and is the matter speaking for itself. If the answer for all these questions is yes, that means you are good. And I am bringing it to your attention the judgment in a cardinal case. This is a judgment in Jacob Matthew case in Punjab. In this case, in the appeal, in this case, the Supreme Court has set so many points to be considered in deciding whether there is a negligence. That means it is a 97-page judgment in which the Supreme Court has set some guidelines to proceed, how to proceed with a case against a doctor. That means a doctor may not be arrested in a routine manner simply because a charge or an allegation has been leveled against it. This was again reiterated in the Martin D'Souza versus Muhammad Iftar case in 2009 in the Supreme Court. That means before proceeding with a case against a doctor, it should be referred to a competent doctor, preferably in government service or a committee of the doctors. That is why when there is an allegation of negligence, always the government or the concerned agency will appoint an inquiry commission to evaluate whether there is prima facie negligence. Dr. Jacob Matthews' case, again, the Supreme Court has said that doctors are working in a sphere where 100% success cannot be guaranteed equally in all the cases. That means you are doing the same procedure in 3 different individuals, but you are getting 3 different results. That means it is not a negligence, but you cannot assure that the same result in all the individuals because it is not the doctor factor alone, because there is a patient factor. There are other factors which are giving the result for the procedure which is done. And recent judgments in 2014, the Punjab High Court has exempted doctors from the Consumer Protection Act, but When a state high court is exempting somebody from that is applicable only to the state. In other cases, the Supreme Court has set an 11-point norm on medical negligence. Again, it was relying upon more on the judgment in the Jacob Matthews case. I am not giving you the details of the Jacob Matthews case. We will just, if somebody is interested, we will discuss it in the discussion part. And legislations against mob violence. Recently, what you have seen is when there is an allegation of negligence, there is a mob violence and there is a media judgment or a media trial. That is what is going on here. And the first two states to come out with a legislation against mob violence was one was the Tamil Nadu Medicare Service Patient and Service Institution Act 2008. And Kerala government also is having a Hospital Protection Act, which protects the doctor from any allegation of negligence, which is addressed by violence at his institution, or by attacking the person or anybody subordinate or supporting the doctor. That is also, and it is a non-bailable offense, and imprisonment is up to 3 years and 10 years, 3 years up to 10 years. And I will give you 2 points. One is vicarious responsibility, liability, and last opportunity rule. Vicarious responsibility, I will explain in this way. That means you are appointed by an institution. For example, I am appointed by the Kerala government. All the actions are done by me will be having a vicarious liability on the government because it is a master and the servant relations. All the actions done by the servant are liable, or liability is resting on the government also. Same is the case in the private institution also. You are appointed by an institution and you are getting a salary, paid salary, you are working for a salary, and means if there is an allegation of negligence, the vicarious liability rests on the institution also. Last opportunity rule, I will explain. You are the supervisor or the senior doctor in an institution. You have got 2 assistants working with you, maxillofacial surgeons. Your assistant is doing a procedure. Just by your experience and clinical observation, you know that the person at the doctor, your junior doctor, is likely to cause a complication. When you are there means you have to interfere. Had you interfere on time, the complication or the resultant injury would not have occurred. For example, a use of an extraordinary force by an elevator, which can result in the fracture of the mandible. You know as an experienced person that this much force is not required and can result in an injury. So you have to, if you had not interfered on time, that means the responsibility, the major responsibility on you, that the last opportunity rule is violated. Documentation. This is the part where we maxillofacial surgeons and general dentists are also good in doing the work. But what we are lacking in documentation. And if you are, the patient may forget the details and what are the procedures done, but if you are documenting everything either as a hard copy or as an electronic copy, these documents will speak for you if there is an allegation of negligence against you at a later date. What happens is whenever there is an allegation of negligence, the police or the concerned authority will confiscate the files in which, whether it is an electronic file or it is a paper file, you will not be able to enter anything on that later. So any procedure done, any consent taken, which Dr. George Paul will be dealing in detail, has to be entered properly. That is, documentation is most important for us to save our skin and to face it in if there is any litigation. Resolving the complaint. Sometimes the complaints may not be directly linked to the complication or what is the net result of the procedure, but it is the way you have talked. It is the way you have talked. That means if it is a trivial complaint or if it is a minor injury, an apology will be saving you from the patient proceeding for a litigation. Correction of a damage cause. That means there is I'm just deviating from maxillofacial surgery to restorative dentistry. You have done a jacket crown. The patient is not very happy with the aesthetics of the crown. In which case, if you are just correcting the damage to the satisfaction of the patient, that will avoid the litigation. Or if you are not able to do that, referring the patient to the appropriate patient who can correct it and you bearing the expense. And paying, if you are doubly sure that you are likely to be booked in the court of law and there is a damage caused by you, either by negligence or otherwise, and paying for the damages sometimes, I repeat the word sometimes, why? Because always don't try to settle it outside the court. In some cases, selective cases, settling it outside the court will save your time a lot because litigation may take years. All of you like to be remembered, but remembrance in this form, it is engraved in stone for lifetime immemorial. You and me will not like. So always, when you practice, be ethical and be moral and be lawful in your practice. Healthcare is out of the consumer code by the Consumer Protection Bill in 2019. But even though the patient is not able to approach the consumer court straight, the criminal liability rests in so many sections of the Indian Penal Code, from simple hurt, grievous hurt, endangering life, deaths, 304 or 304A, due to rash and negligent act. The peculiarity of 304A, that is Malayalathi parana manapur non-intentional deaths or the resulting in deaths. It is not intentional, but unfortunately it happened. It is a cognizable offense. That means the police officer can initiate an FIR based on the complaint of the patient. But it is a bailable offense. That means it is bail is a matter of right. You are getting straight bail from the station itself. Station bail because it is included in CRPC Schedule 1. And it is non-compoundable because you cannot pay a sum of money and blood money and solve it. Thanks for my senior friend, Dr. George Paul, because he is the person who has brought me into law and into the presentation also. Thank you very much. I thank the AMSI also for giving me this opportunity. Thank you very much.
Thank you, Dr. George Correa, for that very informative lecture. It is actually a new information for me, at least, that the healthcare is out of the Consumer Protection Act now. We will have questions later. We will straight away go to the next lecture now. I invite Dr. Varun Menon to introduce the next speaker, Dr. George Paul.
Thank you, sir. Our next speaker of the day requires no introduction. He is none other than Dr. George Paul, renowned maxillofacial surgeon and lawyer. Sir has extensively written and given lectures on medical legal aspects of dentistry in general and maxillofacial surgery in particular. His contribution to AMSI are innumerable, and he is often called upon for his expert opinion in various medical legal issues. He is often the go-to person in case of medical legal trouble, not only for maxillofacial surgeons, but from other medical specialties also. Requesting you to start your presentation, sir.
George Paul, sir, your mic is muted, sir.
Sorry about that. I'll start again. I am down with the COVID, and if I'm not very audible or very clear, please excuse me. I was scared that I may not be able to make it for this talk, but I've been feeling much better since afternoon today. I'm going to talk about informed consent, and George Correa had given, I dealt with a very, very long topic in a very short time. And I thought that informed consent is also a very elaborate topic, and I'm going to try to do the same thing. So towards that end, I'm not going to talk about informed consent as such, because I assume that all of you are familiar with informed consent, since you may be, all of you must be using informed consent in your clinics or in your hospitals. What I'm going to talk today is about some aspects of informed consent which you probably are not familiar with, and also something about how you deal with people who are dissatisfied with subjective issues. Subjective issues which pertain to dissatisfaction of aesthetics, that some patients may complain about. That's a very complex issue, but I'm going to spend a minute on that. I'll try to be as fast as possible on this. So just to recap, we know that informed consent is basically a consent given by, sorry, Ram? Sorry, Ram?
I'll mute all the mics and then you can unmute yourself.
Is there a disturbance from my side?
Yes, I think so.
Is there a disturbance from my side? No.
Sorry. Unmute and speak, sir.
Yeah.
Sorry,
is it okay?
Yes, fine.
Okay. Basically, an informed consent is a consent given by the patient to do a procedure on them. They're giving us permission to do so. And in doing so, you need to give them certain information, which includes the benefits, the risks, complications, so that they can take a decision that is very clear and unambiguous. And this is basically an expression of the ethical principle of autonomy, but it also involves the ethical principles of non-maleficence, beneficence, and justice. But you must understand that informed consent primarily deals with autonomy as of the patient to decide to allow you to do something based on his consent. So that, just to give you an overview on that. And as George Currier said, informed consent, negligence is a major issue. It's the most important issue as far as medical legal aspects in medicine or dentistry is concerned. And lack of informed consent, if you look at it from the point of view, my personal experience as well as published data seem to suggest that more than 50% of the cases, one of the issues that comes is we did not know what you were going to do to us, or we were not aware that this kind of a problem can occur. So a lack of an adequate informed consent is a very important reason for most of these litigations. Now, there are two aspects that I would like to deal with first. One is a lot of people believe that if you have an informed consent, then you can do anything and get away with it. You cannot, and I'll deal with it in a subsequent slide. So informed consent, getting an informed consent does not absolve you from all the possibilities. But at the same time, you must remember that if you do not have an informed consent and you have a complication which is expected, like for example, paresthesia of the lips after an impaction, you possibly can get it. But if you do not have an informed consent, it becomes negligence. But if you have an informed consent, it might help to salvage the situation. So it's a redeeming factor. Now, you need to understand both these aspects. Informed consent can't save you, but at the same time, informed consent can save you from situations which are highly expected. So, as I said, informed consent involves explaining the risks. That's what you need to understand. So I'm going to just concentrate on certain aspects of informed consent which you might come across. So one of the common questions that people come up with is what risks should we explain? I mean, every procedure has a large number of risks. Some of them are expected risks. You may think that it is too small to be explained to a patient. Some of them, if you explain to them, they would never have that procedure done. You can frighten the patient away. So there is what is called the prudent patient test, which means what a reasonable, the keyword is reasonable, what a reasonable patient might expect in a procedure. And what he may not expect in the procedure is what you need to include. Now, what I'm going to do is I'm going to take a case of orthognathic surgery which is in Kerala, it's a very popular procedure, and discuss that, the possibilities and problems that you need to explain, which are expected, which patient may not expect, and which probably you can avoid in your informed consent. So obviously, the price for a better face is both risk and money. Money you put into your pocket, and risk you put into your informed consent. Now, what are these risks? These risks may be complications or maybe sequelae. So sequelae means it's a very high percentage of something happening is a sequelae, and complications can be things that can happen because you've done something wrong. The doctor has done something wrong also. So let's take an example of BSSO. Now, it's a very complex procedure when you look at it, in the sense that you're dealing with fracturing the bone at two places, the nerve running through it. But at the end of all that, what you get is aesthetics, and that's what a patient has come for. And of course, there are other issues like function and structure, which the patients don't really appreciate very much. So I will deal with aesthetics at the end of this talk for a minute, but what we need to understand is that the patient comes to you for aesthetics, and the price he pays is some risks. And what are these risks? See, you would expect that a patient who comes to you for a procedure would reasonably expect that it would have to be done under anesthesia. So you don't have to tell them that this procedure is going to be done under anesthesia. Hospitalization, obviously it's a major procedure, so patient will have to be hospitalized, although many orthognathic surgeries are done on an outpatient basis as well these days, particularly in Europe. Any surgery would have some amount of pain and swelling. There would be the surgery being done in the mouth, you would naturally expect some difficulty in eating, and a few days rest is an expected situation. And of course, there would be a change in the face. How different the change in the face is something we cannot really predict, in the sense what the patient expects and what you are about to deliver are two different things. Now, these are things that a patient would reasonably expect, and you probably don't have to implicitly put it down in your informed consent. On the other hand, there are several things that a patient may not foresee. For example, you may say, we will keep you in hospital for 2 days, but you may end up keeping them for 4 days or 5 days due to some complication or some reason which merits it. Now, one of the most common problems is neurosensory deficit in almost all the orthognathic surgeries that we perform, whether it's a Lefort 1 or BSSO or even a genioplasty. You would expect some kind of neurosensory deficit, which is quite common. Occlusal discrepancy, obviously, especially if you're doing surgery first and orthodontics later. And associated things like condyle sag. Sometimes, very often, we may have to do immobilization or put elastics for them. These are things that patient may not be expecting, that you would have to close their mouth up. Extraction of teeth, last molars may have to be extracted during a Lefort 1, for example. And you may tell them that you're going to put in 4 plates or 5 plates and end up putting in 6 plates or 7 plates, which has implications on the cost. Many patients have PM joint problems. So these are things that they may not expect, and you will have to put it down, because if they develop any kind of dissatisfaction with any of these occurring and they do not know about it, there is an option for dissatisfaction and therefore litigation. As you know, orthognathic surgery, especially let's say SAG, is a very complex surgery, and there are recorded complications that are published in several places, and most of you probably have experienced it. One of them, which I experienced, and I've talked to several people, is nerve damage or neurosensory deficit. 12.1% is what this literature says, but I would put it at something like 30 to 40% in my hands, and some people say even more than that. The problems with fixated exposure of plates, temporomandibular joint, undue fractures, bad splits, and scarring. If you're going through the skin at some point and the patient has a hypertrophic scar or keloid It's a problem that you can have hemorrhage. These are, I mean, recorded complications that you can have. Now, at the end of all this, some people may ask, and I'm sure, and as Joseph Edward had mentioned in the beginning, you can have death, for example. Now, do you tell the patient you may also die while we do this procedure, and you're not going to have anybody doing orthodontic surgery with you? Tracheostomy, I mean, I've not seen the necessity for it, but I'm sure there have been instances where tracheostomy is needed. Loss of vision, I know at least about 3 or 4 cases where there has been temporary or permanent loss of vision of one eye at least. Carotid cavernous fistula is another thing which I've heard from surgeons occurring. Now, if you tell them these kind of things, which are extremely rare, and the thumb rule is less than 1%, you may not actually have patients acceding to it and allowing you to do the surgery. So I think some of these you might be justified in not actually addressing and in your informed consent, and still being able to get away as acts of God, as they call it in law. Now we look at the situation where an informed consent may not be able to save the person's, save the surgeon, because what happens in these situations is that although you have an informed consent, if the patient can prove, again, the burden of proof is on the complainant, that despite having given an informed consent, I'm sure if the patient had exercised due diligence in doing this procedure, I would not have had these problems. If the patient can prove, like Recipsa loquita, for example, which George Curry had talked about, or if informed consent is given by coercion, I mean, or by a fiduciary relationship, you tell your clinic staff that you're going to do it. You can have these kind of problems. Sometimes, very obviously you have not one bad split, but 2 bad splits. It might actually reflect on your the way you do your procedure. So, it is, there is this Bolam test and Bolito test. Bolito test is, where you, in negligence, is a test where even if it is an expected situation, you need to use a judicious analysis of that situation. And if it is obvious to a judge, to a legal officer, that you have done something wrong, it can still go against you. And one thing that we very often miss is the fact that orthognathic surgery, for example, we often take HIV informed, we don't take an informed consent, we do HIV test. Many people do not know that you need to have an informed consent for HIV. You may need a separate informed consent for orthodontics. Again, I mean, even me, we rarely take an informed consent from the orthodontist. Anesthesia, of course, most hospitals would have an informed consent. And in children, of course, you know that special informed consents are required, and also among literates and people who are incapable of contracting. Subjective, just a minute on subjective dissatisfaction. Many people, this is a very serious problem, but I'm just giving a minute for this, but many people actually come back and say, thank you for having changed my face, but I don't like my face. Now, this is a big problem because it's very difficult for the judiciary or for doctors or the people who are peers of yours to actually make a decision on whether the person looks better or worse. And very often I see orthognathic surgery pictures and I think to myself, the before picture was better than the after pictures, so but some people have body dysmorphic disorder, which is a major psychiatric disease where even small imperfections are seen as major blemishes, and they are likely to go in for litigation. There are people who commit suicide, and I know quite a few people who have been at the receiving end of people with body dysmorphic disorder. This is something that people should know, especially if you're doing orthognathic surgery. A classic example of a person who had body dysmorphic disorder was Michael Jackson, as you can see, a very handsome young man who slowly deteriorated because he was unhappy with his hair, his skin color, his nose, his lips, and finally he ended up looking terrible. So this is what happens, repeated surgeries. We need to be very, very careful, and because you can burn your finger with these problems. So in summary, I would say the absence of a good informed consent, it can become negligence. So do take an informed consent and due diligence with informed consents. Most of our informed consents are inadequate. Complications, even if you have an informed consent, if you have complications, you can still be in trouble if you do something wrong, but it is on the onus is on the patient to prove it. A good informed consent, of course, has no limits, because today you have video informed consent, a whole lot of other informed consents, which is making informed consent more complicated, particularly in research informed consents. And I thought we need to deal with it. And of course, this is now we have informed consents like using braille, video recording, and of course, always it has to be in the language that patients understand. Thank you very much. I'd be very happy to answer questions.
Thank you, George Paul, sir. It was highly informative. A lot of doubts which I personally had have been answered by this, and I'm sure that that is the case with many others as well. Still, there are doubts abound with many of us. We shall go into the discussion session. We have only 30 minutes for the discussion session, so we have to be really hurrying up here. Shall I start with the question to George Correa, sir? This question of consumer court and a regular court. Now that healthcare is out of the Consumer Protection Act, is anything actually changing? In what way is a consumer court or a case in a consumer court different from that in a regular court?
Because
GP sir can also answer if you, yes?
Yes. Previously, when there is an allegation of negligence, the patient is interested in going to the consumer court. Why? Because only a white paper is required to file the complaint, no advocate required, and the procedure is very fast. But now, even though patients that what it is called, the patient can approach the criminal court, filing you under, charging you separate section. That means a criminal liability is there and a compensation is also. Procedure, for that procedure, you need an advocate, whether it is going to be a blessing or going to be a problem is in the individual case. Previously, it was very advantageous for the patient. Now the limit for the consumer court has also been increased to 1 crore. And criminal liability is with the first class magistrate court. They can file a complaint with the first class magistrate court. That means, yes, doctor has for such and such negligence and the resultant injury is there. For that, they may call for an expert witness, the records, or everything the patient has to submit. Now also, the liability doesn't end. The court, it has moved from consumer court to the criminal, the magistrate court. Dr. George Paul, can you elaborate?
Let me first clarify. I think it's wrong information that it has gone out of the consumer court. The reason why this information, I mean, I'm sorry, I have to contradict this because I've been doing this at a different foray. Now, the reason is, you need to understand, the reason why this concept came, and it's mostly from WhatsApp University, is based upon the fact that there was a draft of the Consumer Protection Act, which was first sent out. And in the draft, a number of professions were mentioned. And the medical profession was specifically mentioned. And as people which were the areas which came under the Consumer Protection Act. Subsequently, when the amended Consumer Protection Act came, the name of the medical profession was not explicitly mentioned. And for this reason, I'm sorry, I didn't stop sharing. And for this reason, what has happened is that people are under the impression that because it was not mentioned in the final output, doctors are exempted. It's not true. What has really happened is that if you read it carefully, it says a number of professions are mentioned, and finally they say that this does not amount. They make a very clear exclusionary criteria which says this does not purport to add other professions or something like that. So there is nothing that is mentioned that it takes doctors out of the ambit of consumer relationship. As long as there is, and another thing which George Correa mentioned in this presentation was contract of service. It is not contract of service, it's contract for service, and often for are two very, very important words that need to be mentioned. In fact, the IMA versus VP Shanta case went right up to the Supreme Court based on whether the service of a doctor is contract of service or contract for service. It is contract for service, which means you provide service, the patient gives you money. And as long as there is a commercial transaction of somebody providing service and somebody giving money, it remains that it is still within the ambit of the Consumer Protection Forum. Somebody has been writing this thing on WhatsApp. It's been going around and round and round. It is very clearly mentioned in the thing. I can actually send that exact words that I used in the amended Consumer Protection Act, which clearly says that these professions, the mentioned professions, it does not mean that the other professions are not included. So merely not mentioning the name of the medical profession does not exclude it from its ambit. And second thing is, if it is not to be taken up in a Consumer Protection Act, to clarify what Scaria said, it goes to a civil court. It doesn't go to a criminal court. Criminal court is, it goes only if a criminal case is filed. It goes to a regular municipal court, and or maybe it may eventually go on appeal to an district court and things like that. But as he mentioned, you have to pay a court fee. That is the issue, not just the cost of the advocate. You have to pay a court fee. In a consumer protection case, you don't have to pay a court fee. But those things don't matter anymore, because it is a wrong information that doctor services are excluded from the Consumer Protection Act. There is nothing at all that excludes it clearly.
Yes, I agree with what Dr. George Paul has said, but what I mean, the patient has got different options. Services are not exempted, but maxillofacial surgery or medicine is not explicitly included. So and I agree with Dr. George Paul in saying that it will go to the civil court for compensation. But the criminal charge of negligence can be charged in the other court also, because there is a criminal liability also. Patient can go to the civil court for the compensation as well as for the negligence. There is a death, 304A is not chargeable in the civil court. There is a death of a patient will be in the criminal court. That means it is a negligence and it is triable in that court, but the compensation will go to the civil court. And services are not exempted. I agree. Any service, when there is a contract to service, will be included. That I agree. Now,
Ravi, I think I didn't explain this. I didn't explain this well enough. Now, let me make it very clear, just so that people don't get carried away by this. Doctors and doctor services still come under the purview of the Consumer Protection Act. It has not been excluded. It has not been excluded.
Yes, that is not disputed. That is not disputed. Scaria sir is not disputing that.
no,
Yes.
I disputed that.
We need to go into other questions because there are lots. One question about the consent was, is there a validity period for consent? Can the patient say that I had given this consent 1 month back and the situations had changed by the time of surgery, and is that possible? One more sub question is that who all can sign as witness? Can the relative of the doctor or relative of the patient, somebody signing as witness, is that valid?
Yeah. To the first question, time bar on consent. Now the thing is, if a person has given consent for a particular procedure, there is a significant amount of burden on consent today, because what has happened is the benchmark of consent has changed significantly over the last 100 years. Initially, it was just consent, then it became informed consent, then it became the quality of consent, the language of consent, all those kind of aspects. So time is also a matter. So at the time of giving the consent, if there was circumstances which justified the consent procedure, then it would be accepted. But if something had changed in the intervening period, let's say 1 year later, the circumstances had changed, there were new procedures, new techniques, new which were options were available to the patient, then obviously the patient can say the consent was faulty. Now, more and more people are finding faults with the consent procedure, saying that just merely writing it is not enough. You need to videograph it. You need to have witnesses and things like that. So the quality and level of consent is constantly under scrutiny. So time will be a factor, yes.
And I wish to add one more point, and the consent has to be countersigned by the doctor. And
Yes.
it was a judgment by the High Court that if a consent is not countersigned by the doctor, it is not a valid consent. One. Now, that is a part which we usually miss. And another thing, asking a patient to sign a typewritten or a printed paper may not be found valid. You have to describe the procedure for the patient, and the patient has to understand that. After understanding, and another thing is, don't give a consent in Malayalam to a Bengali, because the consent has to be in his own language, understandable by him. If he cannot understand, means it has to be dictated to in his language, and he should understand, and then that has to be countersigned by the surgeon doing the performance. These are because of the judgments. Whether it is a leading judgment or somebody is going by that or somebody is not going by that, it depends on the court.
The second question, Ravi, is about who can sign as a witness. Yeah, normally in research, at least, they're very strict. It has to be an independent witness. That is a person who has got nothing to do with this thing. It has to be an independent witness. But usually, a witness, patients, relatives, and things like that is accepted in a hospital or clinical environment. But in research, they often specifically mention that it has to be an independent witness.
Okay, we'll move on to one very important point which has been raised by one attendee. Hair transplant done by OMFS. Can that be considered? Can that be accused of medical negligence as fraud? This really is very important because, especially with the lack of medical degree, practically any surgical procedure can be said to have been accused of having fraud by the lawyers, isn't it? Or any aesthetic procedure on the face.
Who needs to answer? That's correct.
Any one of you. Yeah.
Oh. Hair transplant has been in the news for quite a long time. I think a lot of people doing hair transplants, and they're finding themselves at the end of the professional stick rather than the legal stick. There are other professionals like dermatologists and plastic surgeons who are objecting to it. Now, we are bound statutorily by the Dental Council of India. And the Dental Council of India clearly says that you can do reconstructions as part of the curriculum for maxillofacial surgeons. Reconstructions include skin grafts, flaps, etc. And if you can graft, if you can take a flap, or you can give a graft or split thickness graft or anything like that, why cannot an appendage in that skin be grafted or transplanted? So if you analyzed it, I see no reason why hair transplant cannot be done. At least in certain, if you want to call it, if you want to exclude the calvarium area from the facial-maxillary region, you might have a problem. But and say that I can transplant hair on the lip in a cleft lip patient, but I can't put transplant hair on the top. But those are actually, splitting hairs, really. So I think if you go by the literal analysis of what the council's statutory requirements are, I think you can do a hair transplant. There's nothing that can stop you from doing it.
Thank you, sir. Another very important issue coming up is very frequently this happens that we do a surgery and there is an anesthesia complication. So we feel that the anesthetist is more responsible for it, and there may be something which might have happened because of the lack of care from the nurses. So in a situation where more than one person is dealing with the patient, or maybe there is a power failure and something happened to the ventilator. So in such cases, who can actually be accused of medical negligence? What usually happens and what is the legal position?
You want to answer, Karia?
Yes.
Yeah, I had told you about vicarious responsibility. When you are appointed by an institution and there are so many people involved in the surgery, anesthetist and the surgeon, you are responsible for that part of the surgery. It is a part of the responsibility on that, and vicarious responsibility lies with the institution also. The first responsibility lies with the institution and the person performing that act of anesthesia. If it is an anesthetic complication, for example, I will give you a maxillofacial surgeon has conducted a leaf-osteotomy, and 7 or 8 days later, the patient collapsed and succumbed to death. And the patient was extubated, unable to intubate again. Tracheostomy was done, but the patient died. And there is no point. And in this context, I would suggest that the surgeon should have a separate advocate. 1. Number 2, the institution's vicarious liability should be highlighted. And number 3, and you can have an expert opinion because the courts admit expert opinion, especially by the government. I have gone to consumer court as expert witness. And the advantage of giving an advantage of giving a expert opinion in the court rather than an affidavit is that there is a chance for the defendant to cross-examine you. And you can, as the trial continues, you can elaborate. So my opinion on this is that you are responsible for the surgical part. Any surgical complication, you are responsible. Any anesthetic complication, anesthetist is responsible. And all the complication, the institution is having the vicarious liability. Am I right, Dr. George Paul?
See, I think it was
before George Paul sir replies, I just wanted to add a sub question. Most of the time, what happens is that the surgeon is admitting the patient. So it is generally considered by lay people at least that as the admitting doctor, the surgeon has the overall responsibility. This is under this doctor's care. How much valid is that?
Okay. Yeah. I'll deal with the whole situation. See, we have different systems of medicine, and many of these laws came out of the UK, where the system of medicine is largely government. It's like a NHS, under the NHS scheme. So if you look at some of the important decisions in this matter, pertaining to this matter for fixing responsibility, I think it was Lord Denning who said, a nurse has taken a medicine and given it to the doctor injects it, and the patient dies. The nurse gave the wrong medicine, the doctor injected it without knowing it's a wrong medicine, patient died. I mean, I'm talking about a simple situation, but in a more complex situation that George Curry explained of how there could be a surgery and patient could die of complications of anesthesia and things like that. So here, first of all, informed consent should be given by different people. There's a separate informed consent for anesthesia, separate for surgery. Irrespective of all these things, finally, when you come down to the situation of a mishap having happened in a procedure for a patient and the patient goes to court, it is very difficult for the court to decide on who did it because it's a highly technical affair. They do not know who has done the mistake. In those kind of situations, what they do is they hold the hospital or the general management of the situation responsible? And to the question of whether the leader of that management team, which is probably the surgeon who has admitted, is responsible. Yes, I think he has a larger responsibility than the others. But generally, within the judiciary, they would rather give the whole responsibility to everybody who was involved in that and leave it to the hospital to actually identify who made the mistake. So this is something that came out of NHS. It's a different system. In a private hospital, it's a little more difficult. And having said this, since Karia mentioned about vicarious liability, we need to mention that especially in consumer protection cases, there's a contract that is built between two people. And if the patient is contracting with the chief surgeon who's admitted, that contract is the valid one in a consumer court. Everybody else who's employed, the assistant of the doctor, etc., or an employee of the hospital, may be having a vicarious responsibility, which means that they're not directly contracting and they're not directly responsible. Now, this doesn't in any way change negligence. Negligence remains. But in a consumer court, it means holding a business contract as the valid contract. It will be between the person who is admitted, the patient to whom the person to whom the patient has gone, and the contract that's developed between those two people. So it's usually the chief doctor, the admitting doctor. But then if they have gone to a hospital, for example, and all the people in the hospital are employees, then only the hospital has a contracting responsibility. All the other people have only vicarious liability if they are employed. Does that answer the question?
Pretty complex. It really depends on the smartness of the lawyer. It looks like pretty complex.
Not
situation.
really.
Yeah.
It depends upon the definition of judiciary. You know, how the judiciary views it. See, if you go to a judge and imagine yourself in the judge's position, and they tell you all kind of complicated things. Patient had a bilateral sagittal split osteotomy and a Leafort 1 osteotomy, and a pushback and intrusion of maxilla and things like that. He's not going to be able to understand. And he says the total airspace has decreased and therefore there was some hypoxia or something like that. If the anesthetist says, and it's not because of his position, he's not the judge is not able to understand all these things. So he will generally say that there has been a problem and it involves several doctors, includes anesthetist, includes the surgeon, the assistant surgeon, and maybe the duty doctor who is supposed to take care of him, or the nurse who's supposed to clean, who's supposed to take care of the patient in the ICU. It would be very difficult for a person in the judiciary to be able to make a decision on that. So they would generally put the whole onus of definitely the patient needs to get justice, but deciding who needs to give justice is something that only a hospital internal inquiry can establish.
So the hospital is sued, and then
and the hospital can decide and say that this person, this person, and this person were responsible. They can do an internal inquiry into it. Again, the health systems are so complicated. NHS is different from a private hospital. A clinic is different from a corporate hospital. So it depends upon the situation.
We are really running out of time. We need to wind up quickly. Before that, we have to really face 2 or 3 very, very important questions. One was, how do you respond to a lawyer's notice for medical negligence? Can Skaria sir talk about that? Suppose you get a notice, lawyer's notice, what are you supposed to do?
The lawyer's notice usually contains the facts and some build-up facts. And what is speaking for you is your documentation, the procedure done, any complication displayed, and the consent like Dr. George Paul has explained. And when you are getting a notice, means check what is the primary allegation. Is there any substance on that? And if you are truthful and you have entered, and if it is a complication, another thing I wish to tell you is, I will give you an example. For a patient, there was a fracture of the mandible or the maxilla for which IMF screws were given. And patient is having trismus following 50 days. For the patient, the complication is, I am unable to open the mouth. He approached an advocate and sent a notice. Like that. Go to the content of what is the allegation? What is the allegation? Is there any substance? You yourself know if there is a complication which you have done inadvertently. And court will agree that complications are likely to occur.
No. Should you respond to the lawyer's notice?
Yes, definitely you should respond. My advice is definitely you should explain your part of it with the statement that if any unwanted litigation is initiated, that will be addressed in the court. You have to explain yourself. Leaving a notice as such is not at all good. Better to show it to your advocate or to your professional protection scheme like AMSI or IDA Hope, which advocate will be able to guide you properly. Don't give a blank reply. Whatever you are replying in that, you are admitting it. That is going to be an evidence in the court also.
That's very important, yes.
Ravi, you need to make a point-by-point rebuttal to everything that is alleged in the lawyer's notice. That's very
answer to each point. Is it?
Usually, it starts with all the allegations and averments contained in the letter is hereby denied, except what is expressed here, admitted here as under. That is our common wording for giving a reply. And then we will say, it is true that the patient has come to me on such and such date. It is true that I have conducted the investigation. It is true that all the complications were having.
So that's all admissions. Yeah.
We will mention that everything went. The patient was having no other complication. Patient left the institute happily, and later on, like that, we will just deny everything what is except what is admitted, and we will give our part of the story. But when we are giving our part of the story, don't commit anything which is not there, because it will be against you. You in your reply has said that it is like that. That is good. So very careful in reply. Better to consult a doctor.
And anything that you put down in your lawyer's notice reply can be used in court against you.
Yeah, that is what
you need to be very careful about.
Very careful.
Okay. Now we come to the real thing. How do we actually defend a lawsuit? You want to throw some light into that, some advice on how it's an actual lawsuit, the notice phase has passed, and about actually defending a lawsuit. Some guidelines, please.
Yeah, can I talk about that? I've been involved in quite a few lawsuits. So when you
Please mute the mic. Others, other than Dr. George Paul, please mute.
George Paul, please, you can unmute and speak. I muted everyone else. You can unmute and speak.
George Paul, please.
We already talked about the lawyer's notice. So usually you get a lawyer's notice, you reply to the lawyer's notice. They go to the court. It depends on which court they go to. For example, if they're going to the Consumer Protection Court, you will get a notice from the Consumer Protection Court saying that you'll have to present. It will have the allegations sent to you. You have to file a reply to that. They will fix a date, and then you have to go for a hearing. Now, consumer protection courts are quasi-judicial, which means that they don't follow all the rules that courts normally follow procedurally. It doesn't follow the civil procedure code. It makes a lot of exceptions. So they may sometimes try to have a redressal, which is not necessarily done in other civil courts. So they might say that, would you like to sort this out amongst yourself, pay him a certain amount of money? These are things that are officially done sometimes in a consumer protection court. So if you're not willing to do that, then the court takes its proceedings. So from the district forum, if you lose, you can go to the state forum to the national forum, you can, and if it's a very complex, technically complex situation, you can ask for it to be transferred to a civil court as well. Because, but civil courts will take almost your lifetime before you get a verdict on that.
Even the consumer courts are taking up a lot of time, isn't it?
I wish to add one point, because maybe because I am in government service, I have been expert witness to consumer. So if you are a doctor, you are having a problem. Get an expert witness from an institution who is having adequate years of experience as an expert witness. Then you can present the case. You have discussed the case with your advocate, the advocate of the doctor. You have discussed, and you can save the doctor. Why? Because you as a senior having 25 years of experience, they will ask you, how many cases have you come across this much, this complication? And you are vouching that it is an accepted complication in the literature, as well as in my last 25 years of practice. This has happened, it means court will accept that. Court will accept, because it is in Indian Evidence Act, it is acceptable. Government doctors are considered as expert witness under Section 45 of Indian Evidence Act. That is not a confirmatory one, but it is a corroborative one. They will not rely entirely upon it. But a senior doctor, I am saying, Dr. Varghese Mani sir is there in the service. And what is the importance of a cross-examination? Means the other advocate is also getting a chance to cross-examine you, and you are getting a chance to present your case even in the cross-examination. Last day, Dr. George Wallace said that affidavit. The problem with the affidavit is that is one side of the story. I will vouch that based on the literature and based on the experience, it is a vouching. And if you can get an expert witness, he is a person who can help you a lot in defending you the case. Actually, the expert witness is getting a grilling time. It will take 45 minutes to 1 hour. You are being grilled by both the persons as well as the 3 persons in the court. So you are getting a grilling, especially by the defense lawyer or the petitioner's lawyer who has filed the case. He is trying to get something out of it. We are trying to get nothing out of it. Because as a profession, we will help. But I am telling from my experience that when we are giving the evidence, we just got a material value to the court.
One more point. I think both of you agree that if you are accused of medical negligence while you're working in a hospital and there are other respondents also involved, like the hospital itself and the anesthetist or the nurses, you should have your own advocate and you should argue separately. Is that right?
Yes, that is the point I wish to. 2 points I wish to highlight is one. Is that advocate rather than going with the advocate of the institution, because you know absolutely that it is not your mistake. It is a mistake which happened in the hospital, for which the administrator or the hospital is the responsible agent. You are the person who has admitted the patient. 1. Number 2, you get an expert witness to explain your side of it. That is my advice.
See,
what about
Ravi? That's not written in stone, in the sense it depends upon the circumstances. Now, if all of you have a certain role in some mishap that's happened, you can even go with the same lawyer. But if you are absolutely clear that there is nothing wrong has happened from your side, do not mix up your case with others. Because finally, when they find, as I said, the judiciary tends to find a negligence in toto for the whole hospital, you will be one of the participants of that negligence. So if you feel that you are not part of the negligence has taken place elsewhere, it is better to have a separate.
I think that is what Skares also meant.
Yes, exactly. Argue your case separately.
Dr. Ravi, can I have a word at this point? Yeah, I think please. Dr. George Paul, that is what has happened in my case exactly. I think because as if I can narrate that through a small thing, taking a minute or two, the case which I operated, Leaford 1 osteotomy with the genioplasty, the day got a bit late because it started late and ended late. So the anesthetist was very keen not to extubate the patient. So they kept in the tube, and the very next day, they planned for an planned extubation. And when they extubated the patient, they went for a respiratory distress, which when they tried to re-intubate, they couldn't, followed by a tracheostomy, and the patient went for a cardiac arrest, following which they resuscitated the patient back. The patient was on ventilator, and it was being treated by the multidisciplinary approach. And the 7th day, the patient went for a cardiac arrest, and we lost the patient. So in this particular case, when the case ended up in that particular day, the patient was quite conscious, orienting with the tube intact, and the bystanders have seen the patient very well. They know what it means exactly. The surgery has come out well, everything is fine. So that if I dealt separately with a separate lawyer of my own, I think in the district forum, I should have won it, or should have easily got out of it, right, sir?
Yes.
Yes, definitely. I think you made a cardinal mistake in getting yourself entangled with the defense
IMA.
along with the hospital, IMA and the hospital. You should have just taken a separate lawyer and then done it yourself. They would have found out and said that, no, this surgeon has done his surgery, is not. And not only that, you are an employee at that time, isn't it?
Yeah, I was an employee, salaried employee.
So
that
salaried employee means that yours is a contract of service and not contract for service, which means that you have the responsibility is vicarious, and you should not have been personally held for negligence at all. The hospital should have been held for negligence.
Let me add.
Now it's too late. Now it's too late to go back.
Dr. Joseph, let me explain. Because when an anesthetist is extubating a patient, he should have all the preparation for re-intubation. If the re-intubation fails, anesthetist is having the alternate LMA mask is there. They are having so many alternative measures, and the last being the tracheostomy. That will, he should be prepared with that. That is the responsibility of the anesthetist to face a difficult re-intubation in every patient. When I was in Calicut, I have seen that they are doing. Anesthetist is ready with all the equipments for extubating a patient which we had operated on the previous day. If the anesthetist has not done it, the surgeon is not at all responsible for the laryngeal edema which is occurring. The laryngeal edema is one due to the procedure intubation and the retention of the tube for so many hours, which he had to foresee. And another thing, in your case also, you put an expert witness. If you put me, I will come and save you. Don't worry. I will come. You put me expert witnesses, which who can.
It's a little too late. It's a little too late. He's already gone past
even when it is defended in the district forum.
No. Once you have given all your evidence, that's done. That's it.
It will not come in the appeal court.
You cannot bring it to the state forum.
No, we have lost it in the district forum. Now it's in the state forum.
See, you put it an interlocutory application for an expert witness to be examined. You put an LA in your Let me explain.
This is becoming too technical for laypersons.
Just too technical. Interlocutory application means you want to get a particular relief, immediate relief. It is a procedure in the civil criminal court. You are having a OP against this. You can't just, I want an expert witness to be examined. You just put it as an interlocutory application that will be allowed. And then you bring I don't say you have to bring me if it is me or X or Y. They will vouch for you stating all these complications. My part of the surgery is once the anesthetist has given the patient under anesthesia and asking you, are you ready? When they are asking, are you, after stabilizing the tube, they will ask you, are you ready? Yes, I am ready. Then we will ask them, can I start? Then we put the local anesthetic plus adrenaline. Shall I start? So you put the incision. These are the procedures. Once the procedure is going on, I personally look into the monitor whether everything is, but it is the responsibility of one. Your surgery part is over.
We'll leave them alone.
I will complete it.
We're not talking about the procedure. We're just talking about the legal aspect.
Everything, and the patient is shifted to the ICU. The person in charge of the ICU is the anesthetist. Surgeon is not in charge of the ICU. The ICU is in charge of the anesthetist or the anesthesia department. They have to look after the patient. You will look after the surgical complications of the patient. If there is a bleeding in your surgical site, you have to intervene. If there is a respiratory problem, the anesthetist is the responsible person. And you should have somebody to explain this in the court for you. If Dr. George Paul said that that is not permitted in the appeal court, means you file an interlocutory application. I need an expert opinion from somebody. The court may examine it.
Joseph Edward, in the present
Yes, sir.
circumstance that you are in, it is not, see, when you go in for the trial at the first level of the court, that is a district forum, you have brought out all your evidence, everything that is there, your complete narrative has been already been
Given
vetted by an accepted set of judges, which is, the people sitting on the forum. Now, once you go on appeal from that forum to the next forum, which is the state forum, you cannot bring in any issue which was already been discussed in the district forum. So you cannot bring in fresh evidence there.
Okay,
That
sir.
is not
Sir,
possible.
we are.
The only thing that you can do is to transfer it to a civil judicial process, which will of course take many, many more years, for which of course you'll have to pay a court fee and everything else.
The interest also will increase.
Huh?
Interest.
Yeah, with interest and everything. Even here, the interest is paying.
There is interest. That is
Now, for 15 lakhs, it has now come up to 28 lakhs after those 14 years now.
Yeah.
So I don't know how much it is going to go up again.
So this is something.
Then it will be within three.
Matters of fact, which Skare is talking about, cannot be used at a later part of a case. Matters of fact, matters of law. If it is a legal mistake that was made, matters of law in process of procedure, that you can bring in. You cannot bring in new evidence saying that actually I was the surgeon and I had nothing to do with it. At this point, you cannot bring it in. It will never be accepted.
We will need to move away from this.
Not even do an
not bringing an expert witness is a legal mistake. I will say that you can. It depends on the individual courts. Individual courts. If you are ready to bring up your case well, an expert witness was not summoned. I may be permitted, just to give it a chance, I may be permitted to bring in an expert witness and interlocutory application. If the court permits, they will offend. The petitioner will object for that on the reason stated by Dr. George Paul that he has brought all the evidences. But still you can win. That is what I am saying. Expert witness. Because court is a layman, he knows only the law. Court, as far as medicine is concerned, he is a layman. So somebody has to explain it to the court. That should be believable to the court. That is why they are bringing people from the government medical colleges and dental colleges, expert witnesses. I have been expert witness for so many cases. Because that is...
Sir, I think we need to agree to disagree there.
Yes, okay.
Because this discussion now it is going is about one particular case and it is beyond the scope of our general discussion.
Okay.
This is just meant for a general idea, giving a general idea to the participants, isn't it? The time has really passed. We are now really out of time. So one last point which we need to discuss is how important are indemnity schemes. IDA has an indemnity scheme. AOMSI was thinking about one. Do they really help, and how important are they in this situation for a clinician? Is it really important for a surgeon to take a indemnity policy?
Definitely.
Yes.
Definitely. You should. Everybody should be indemnified. And
There
don't
are
indemnify yourself for 5 lakhs and things like that. If you're indemnifying, indemnify at least for 25 or 30 lakhs, because remember the district forum has a pecuniary jurisdiction of 1 crore. So people are going to ask for. So definitely you need to indemnify.
There are accusations that the IDA things do not work practically in many situations. When you really face a case, there are problems.
Devi, I have got an answer for that. I am also personally of the opinion when IDA is somebody in the Indian Dental Association is having a case, they will just transfer it to the IDA and sit ID. You doctors or the person who is facing the litigation has to explain it well to the advocate, because the advocate is also not well aware of the facts. He has to present it into the court in such a way that it is convincing to the court. For that, the doctor who is facing the litigation has to be in touch with the advocate in presenting the case. Otherwise, the case is there. Joseph Edwards' case also failed. Why? Because I will say that it is not properly presented to the court. It was not properly argued out.
Yeah, but indemnity policies of professional bodies, not
Highly
professional
necessary.
bodies.
Very good, very good.
So, Ravi, I always feel that I wonder why you need to go through organizations. The only advantage is that if they take the burden of having to go to court away from you, it's fine. But I think if you take a regular indemnity from one of the established services, insurance services, it should be fine. They give you a lot of indemnity, and it's not very expensive. You can take a group indemnity, a large number of people going together, and like the MSI Kerala branch can get it together. You'll get a good.
Associations are also doing it like that. They are getting associated with the fund insurance agency and doing it. Is it not? IDA is doing like that.
I don't know how the idea is.
IDA is doing like that. They are having group insurance policy.
If it's group, it's fine.
They are doing it like that. IDA is doing like that.
It's considering the uniqueness of our specialty, probably our organization should think about that.
I think AMSI Kerala branch should have a separate indemnity scheme that may have its advantages.
But
And all
Dr.
should be
Preetham has brought out.
included.
Dr. Preetham has planned, drafted a well, what they call for maxillofacial surgeons around. He has just come out with they have charted out something with an insurance company regarding with all our surgeries, and they've come out with something. So I think if that works out, it will be better in the national level.
On that positive note, we have to really call it a day. We have gone past, we had hoped to stop in 1 hour, and almost 30 more minutes have passed, and we need to stop. We had a very accelerating lectures, group of lectures, as well as discussion, very active discussion, which I believe have been very informative. I am sure that is the case with many others, many other attendees as well. There have been a lot of questions which I have not been able to address because of the lack of time. Very sorry about that. Hopefully we can have more such sessions to clear more doubts. Thank you very much.
Thank you, Ravi. Thank you, Kerala AMSI.
1 minute. Over to Dr. Akhilesh for the.
Sir, actually, Dr. Manjunara is here, our national president is here. I would like to ask him for giving some concluding remarks if he has anything to add to the present discussion or regarding the indemnity insurance.
Yeah. Hello, sir. Hello, George Paul, sir. Hello.
Hi, Manju.
Yeah, George. Yeah. Yeah, very interesting. I didn't want to disturb anybody, and was patiently listening to this. And good discussion, sir. And as far as indemnity insurance is concerned, the AMSA head office is going through it. Actually, we have shortlisted 2 people, sir. Actually, Epan is not well, so that's why he's taken a weeks off. Otherwise, we were supposed to come out with the one of the companies already presented in Mangalore, something called as a Dockland, and they are actually giving a good, considering all our procedures, and they are coming out with a good scheme. We will be keeping it at minimum 25 lakhs. We will not keep it anything below that. So 25, 50, and 1 crore we are planning to have an indemnity insurance with them. It is going to be a group insurance only. Epan has done a good, he's done a good job of negotiating with 2 or 3 companies. Soon we'll be coming out with the one. So that's about the indemnity insurance. Whether Ravi said whether it's required, yeah, there's no doubt about it, no second thought about it whether it's required. So we'll come out with the indemnity insurance. And as far as the program is concerned, yeah, obviously, nice to listen to the seniors and good lecture program, whatever is going through. So congratulations, Kerala IDA. Kerala AMSI, as usual, a good program. So thank you.
I think Epan sir wants to add something. Sir is also
Epan, Epan. Actually, I put a question regarding the indemnity. Yeah, go on, Epan.
Hello. Can you hear me?
Yes.
No. I just wanted to mention that what Manju rightly said. We assure you on behalf of the AMSI National Office that we'll be coming out with a very good competitive rates, structure, tailor-made indemnity, profit indemnity scheme, maybe in the month of February. So in the last process of a discussion being going on. And like what George Paul sir said, and these insurances are going to take away all the headaches from these members, right from filing or returning the complaints, replying to a legal notice and running around regarding the case. All the headaches going to be taken up by this particular company. They're going to support with all sort of thing, and real negotiations going on. And hopefully, and I'm sure we'll be coming out soon with the detailed project. And regarding group insurance, there's a little bit confusion about, because group insurance, we have to actually fix a slab. Only then these companies will take a group insurance. So we are coming out with the schemes like what Manju said, Dr. 25 lakhs, 15 lakhs, and 1 crore. And with, for example, 1 crore premium, about 1 crore cover is actually, going to cost somewhere around, say, 12,000 rupees only. And that's exclusive and inclusive all the cosmetic procedures, whatever you do. So, and right from the returning to replying to advocates, all those things. So still working on that. And thank you, Dr. George Purcell and Skaria for the wonderful presentation. And that's all from my side.
Yeah, can I just make a point here, Ipan? See, one of the big problems is not so much about the money being given. It's the psychological trauma of having to go through a litigation. So I think the moment there's a litigation somebody faces, the organization, the AMSI should take up everything from, as you said, the legal notice to running it, or even if there is some kind of a settlement, it should be done by the
yes, sir. That's where it's been planned, sir. The moment you get a notice, you just have to forward the letter to those particular insurance company. They have a claim cell. They will allow the advocate on your section on that side. He'll take up the case and he'll actually file the counter for that thing. And you can definitely have the option to choose your own lawyer also if you don't want the company wala. So the option is there. So all these headaches will be taken away, and many features which is not being seen in other indemnity schemes are being added up, including coverage for criminal offense in case that the plaintiff or the petitioner actually files against you in a criminal court also will be covered. Usually the criminal courts are not, the defenses are not being covered by any of those insurance companies. So this also will be covered. And many more features, like what you said. Because considering that pecuniary jurisdiction, what you said for the state forum, now for a district forum is 1 crore and the state forum is 10 crores. So we actually thought of giving only 25 lakhs as a minimum slab, then at least 1 crore. 1 crore coverage is the need of the hour right now, I feel, based on the current Consumer Protection Act 2019.
So can I add a word? No.
Yeah.
Yeah. The thing is, when one faces a problem or when one falls into a mishap, the first and foremost thing what we need to, the association or the association has to back up at the point of time, because what happens here is he will be in a state of totally upset, not knowing what to act on. So the presence of mind he doesn't have has to be supported by the members in that particular area, and the association has to call immediately and get a support for him, either physically or as for his presence, in order to act him properly. Because what I realized was during that particular point of time was I was totally in a state of mess where I couldn't know what was being done. I was exposed in front of the media and I was exposed to the whole world after this particular the day when the patient left.
He has gone out of air. I think.
Yeah, Ravi, just want to add on to that. This one, I agree with. I understand what Dr. Joseph has gone through. In fact, even in the past, I've taken over the president right now, but even including George Paul, both of us were contacted in many of this earlier. Whenever they had any litigation and kind of a thing, we helped them in consoling them, drafting them, and also get a letter from the AMSA as and when required. When the question was asked about the authenticity or the whether they should do, as far as possible, we have done whatever from help in both from personal point of view and from the association point of view. And moving on to what Dr. Joseph says is that I think it's like when an event of this kind of happens, sudden moral support within the surrounding him. I think state chapter should come with this something called as a maybe just one give an example. We have something called as the Association of Medical Consultants. They have something called as a rapid action force, whatever you want to call. Around 10 people. They're all from Bangalore only. This is not just for the litigation thing. A mishap has happened in a hospital, and he calls for some mob is slowly getting into this kind of a thing. One frantic call, and around 10-15 people of them, and just go and stand in the support. No questions asked kind of thing. So I think we are looking into that kind of a system needs to happen in every city wise and kind of a thing. So that is the only way. Suddenly from the head office directly it can't come, but I think each city should have supporting each other's system. That should something which should develop within from head office level. Dr. George Paul, what is your opinion, sir?
Yeah, definitely. It's a good idea. Very good idea.
Yeah, individually, irrespective of cut across, I mean, any maxillofacial surgeon today, tomorrow can have a problem. So in such situation, we should help them in morally, protecting them at that particular time, and also help if the media is, firing them, you help them this one. And in Karnataka, many times I've seen the state dental council actually given many times as expert opinion supported them or most of the people in a good cause. And indemnity advocates, all that will come at a later date, but supporting each other, that is the most important. We should stand together irrespective of, you might have, it might be a mistake, I might have committed a mistake, but at that particular period of time you protect me. Later we'll see, later let the expert opinion and all that can happen. I think that's the only way to go.
Great point, Dr. Manjunath. I think everyone agrees with that. Any more point to make?
Dr. Joseph Edwards should, the president, what Manjunath now has told is a very good point. I think you should take it up in Kerala state and do it fast. Okay, Joseph.
We will do that. We'll do that.
Yeah.
Especially for the youngsters.
Point.
Dr. Akhilesh,
one last point.
Yeah, please.
Yeah, one last point. Can I just say, Ravi, just last point, because I heard from the presentation, Dr. Shaskari, that the 2019 actually excludes this healthcare providers. It does actually exclude the terminology of healthcare providers, but that is actually a clerical error in time, because in the 2018 draft it was there, but in the 2019 thing it was actually removed. Yeah, so it's been actually included. We are actually fall in the ambit of it. Yeah. That's all.
Yes, Dr. Akhilesh.
Yes, I'm here. So I think we can conclude the session for today. I would like to thank Dr. George Paul, Dr. George Skaria, Dr. Ravi Veeraraghvan. Thank you for all for the wonderful session and the discussions following that. I'd like to acknowledge the presence of our National President, Dr. Manjunath Rai, for his inputs, Dr. Preetham. On behalf of AMSA Kerala, I would like to thank all the participants for sharing their doubts. Hopefully, we'll have some more sessions to clarify things. My special word of thanks to Dr. Varun for coordinating the meeting. Kindly forgive me if I have forgotten everyone due to lack of time. Thank you all for attending this. Hopefully, we can have many more sessions like this in the future also. Thank you all.
Thank you. Good night. Good night.